Busuafo na ahwe for yema wakwaba eroba daily update so. Abusu yema breaking news bi eye Abraham Amaliba. Kasa Abraham Amaliba ga Amaliba is senior member of NDC. Na omba omoniga team NDC legal team na Abraham Amaliba ene danom. Abusu we komubo join news na abusu na yebakwa kutie na enkomo no wodi no wode atodwam say Mama Torkono ni picture. My main kind article from City News was a Torkono picture mixing at Supreme Court. Amaliba alleges. Ebushia Amaliba ne bekwa kotino. But Tim Nis was it Mama Torkono ni picture. Was Supreme Court one in ira in the honum the documents in the BBA no. So may ye fraud the Ebushia. Say Amaliba and Allege Sasemano. And in answer Torkono say okay, ye nefro as a supreme as a justice of the what the republic there. And the Supreme Court judges you maintain and on Amarama Abraham Amaliba Allege send the picture and send the picture and the document in a year from say a year from say is mixing in the Supreme Court. Say allegedly say a year from say a question it year from the Busham. You couldn't quote and Koma Amaliba die na me the article na so na enkomo no wodi nkoma fa Torkono enam sa a recent file our file no high court no state.
Yes, the AG can always go to court and ask for time to file his processes. It's been done, we've seen it several times. If the AG is bogged down with other very important matters, he's not supposed to break a limb and an arm. He can always go to court, ask for leave, and then file the processes.
It's almost as though this government is not taking this matter seriously.
I am saying that once the law allows the AG to appear in court and say, can you give me 3 days, 7 days to file my processes, there's nothing wrong. The AG will do it at the right time. But you see, Torkono is becoming a crybaby. A crybaby because at each step in the way, she decides to file processes. Good processes are meant just to stall the legal process that were ongoing. Now the committee has finished its work. This matter, for me, is close. I read part of the relief he was seeking. To say that, in your estimation, the matters that led to her removal were not weighty so as to ground stated misbehavior, it's not for her to say. It's not for her. The committee looked at it and saw that this could affect her and said so. Then there was also another one that she said she is of the view that her salary and her remuneration and all those entitlements should be paid. What happened to her has an effect of saying that she never existed as a Chief Justice.
Counsel, so are you saying you will give her benefits? Is that what you're telling us?
Isn't me, you are talking as if
But I mean, it's your government. You know the mind of the president right now.
Ask anybody, such kinds of removal has the effect. And indeed, I was at the Supreme Court at the conference room of the Chief Justice, and I saw all the justices' pictures on the wall, and her picture was missing. That has the effect of what has happened to her. So, litigation must come to an end. And I think that she's better off, taking this in her strides and then forge the way forward with her life.
Don't you think that things would have been much more easier? Don't you think that things would have been much more easier if, for instance, say she's giving all her conditions? That would have ended the matter, isn't it?
That was what this government sought to do. When she reached out to the president through, I said this before, and she has never come out to contradict me. And if ever she contradicts me, then I'll now let the facts out. When she approached the president through two eminent persons, for her to retire so that the processes will be truncated. That was the intention of the government, to allow her to do that if only she would agree to retire and not go through the process. She reached the president through two eminent Ghanaians. But now that the whole process has gone to its end and we follow through the process, these processes too have their effects. And if it is not for irrationality, if it's not for breach of natural justice, I don't see how these matters can be overturned by any court or entertained by any court.
So when the approach was made, I mean, is it that the president did not listen? The president was not open to, negotiating?
Government was open. Government was amenable. Processes were rolled out only for her, and that was the first time she went to court and subsequently addressed the press. So once she went to court, then the government's hands were tied and that process truncated.
Does this also not suggest that probably all of this that's happening now is premeditated? Is that a fair way to describe it? That, of course, as a government, you knew she was going anyway.
Are you an employer looking for a fast?
What have I said that suggests that? Just ask a direct question.
No, that's why I'm asking you. I mean, because if you go into a negotiation...
So ask a direct question that, was this premeditated? But I've said something and I'm on...
So what, okay, yeah, let me give you that. Was this premeditated, Council?
Whether or not it was premeditated, somebody says whether or not it's still the same. So whether it was premeditated or not... It's clear indication that if you didn't do anything wrong, the premeditated mind cannot act on your conduct. So let's focus on what she did. Was it proper for her to flout the rules governing her leave, the misappropriation of funds? Because she also presides over such conduct by other public officers. When matters come to court, she presides over those things. If she is now caught in the web, and the bar for her is higher than other public officers, that's what she should know. So, no matter how premeditated it was, or no matter how anybody wanted to remove her, if she was clean and conducted herself in a way that wasn't, or that couldn't make it possible for anybody to remove her, nobody could have removed her.
Okay. I'll come back to you. There are some more legal advice you gave to President Akufo-Addo on the initial petition and also the decision to represent her. We'll come to you. Lawyer Abraham Amaliba, let me hear you.
Well, I want to put on record that the committee did not only review the petition sent to them by the businessman, which eventually removed the Chief Justice. I'm aware that the petition that was forwarded to them by the police officer, ASP, I think so, was actually looked into. And, his case was that he was locked up by the Chief Justice. He couldn't find his record of proceedings. And the committee came to the conclusion that was not enough to, as it were, remove the Chief Justice. So I want to put on record that petition too was looked at. It's not only the other one. But in any case,
this morning, Council, the question to you this morning is how did you get to know of all of these? That's what your colleagues are asking you this morning. I mean,
He's speaking on authority.
The claim is that you are speaking on authority.
About events that are supposed to be in camera. Something that is in camera. A senior member of the NDC.
And the whole country is listening.
Even those negotiations that went on in the background.
I get that. Okay. Let's allow him to answer.
It was supposed to be in camera.
Yeah,
It was supposed to be in camera.
Let's allow him to answer.
And now an NDC officer says he's aware.
Council.
I mean, so was that in camera or it was in the house or in the rooms of some group of citizens?
Okay,
He was an ex-official member.
Let's allow him to answer. Council, over to you.
So, if you are asking me these questions, how did I know? Then stop asking me questions that are premeditated questions that are not in the minds of people. You are barred from asking me questions related to premeditated minds. If I can't reveal this, how can I then reveal premeditated minds? So I'm saying that that did happen, and the committee dismissed the police officer's case. But in any case, if the petitions are supposed to remove the Chief Justice, they are not supposed to pamper the Chief Justice. They are supposed to remove the Chief Justice. And after reviewing one, it was sufficient or adequate to remove her. Well, why are you bothered about the other ones? Will the other ones bring her back? Will the other ones bring her back? So, and my senior Ansar will tell you, it is not just about lining up witnesses who will come and repeat the same thing in court. If your witnesses, no matter how many they are, it cannot enhance your case. If those witnesses are just coming to repeat the same thing like what the first witness came to say. So you are better off having just one witness who can make your case and the judge will rule in your favor. So in this case, let's even assume that there was no consolidation. There was one petition, which petition succeeded in removing the Chief Justice. What are you going to repeat the others for? So that to undo the first one, So I want to think that we can put a human face to a predicament now. And that human face has to do with her remuneration, her entitlements, and all those things. Because I'm sure the day that the letter went, I'm sure they would have truncated her salary immediately. That can be problematic. Yes, she may not have a name again as a Chief Justice, but in person, she was once our Chief Justice. You don't want to see our Chief Justice, in a condition that is unacceptable. So we can make a case to put a human face, because this is the first time that this has happened. And so there are no rules to govern these matters. It is now that I'm hearing Parliament wants to make rules to determine these matters. So let's argue for her on the basis that she should be given her entitlement. That's I will argue alongside.
All right.
But to try to fault anything, I can't see it.
All right. Lawyer Ansari, are you still there with us? Have you found the article you're referring to?
Yes, it's Article 1613.
Okay, 1613 now. Okay, yeah, I think the lawyer still looked at that.
Thank you very much.
Oh, okay.
I apologize.
Yeah, I get that. Let me just give a quick one to Echo, because the question on what informed President Akufo-Addo's decision in the lead up to the 2024 elections, of course, there was a petition by lawyer Kweku Asare, not the one on Zoom, but the one in the US. Yes, Kweku Asare. You turned that down, Echo. I'm speaking extensively by the president gave his reasoning, said the Council of State doesn't see any reason on that. Yet another Council of State is now recommending that, of course, there's enough evidence.
First of all, once that matter had been determined, it was wrong for the committee or President Mahama to make a determination.
Is grounding her argument on that the thing against her about the misappropriation of the said funds is false, misleading, irrational, and illegal, because it cites misconduct for expenditure that was neither disallowed nor surcharged by the Auditor General. To the extent that the Auditor General did not raise queries about this, in her view, it's irrational and illegal for you to even use that as a basis for her removal. Also, that this same first finding of misappropriation is also unreasonable and unfair because it attributes unauthorized expenditure to the Chief Justice, though she neither authorized nor administered it. So she's not a spending officer. The second finding is an abuse of power and unconstitutional as it wrongly treats the Chief Justice's lawful administrative duty, and this has to do with the transfer of judges. Under Article 1254, including the transfer of judges and officers as misconduct. It says, the third finding is an abuse of power and unconstitutional as it mischaracterizes the Chief Justice's legitimate role under Article 1254 and established conventions in judicial administration as misconduct. And in fact, it says it's also unlawful, challenges the Chief Justice's conventional role shared with the Ghana Bar Association Attorney General in recommending the promotion of judges. This is the position of the former Chief Justice and what she is seeking in this particular relief, the latest. I saw this path with Godwin Eduji Tamaklo because this is not the first time we're having to lay a matter of a judicial review by the former Chief Justice. There are some who hold the view that this continuous application is an abuse of the court process. Others are of the view that, look, to the extent that this is unprecedented, all these applications must be allowed so as to tick all the boxes, bring clarity, form a strong precedence so that we'll see how the days and years ahead will look like. Before you answer that, let me acknowledge Bracco Powers is a private legal practitioner as well joining us. So Powers, good morning. Thank you for joining us.
Good morning. Okay.
Perfect. Okay.
I'm not surprised that now removed Chief Justice Gertrude Araba Saki Torkono had decided to file this judicial review application. I'm not surprised at all.
Why doesn't it surprise you?
The reason is simple. You see, Alfred, as young as I am, there are certain things that when you are advised and you decide to do otherwise, it goes against you. Look, in the midst of these petitions, two prominent Ghanaians say, look, I recall vividly, the argument was made. The Constitution says, and the Supreme Court has clarified the issue, that once an Article 146 process has commenced, you do not have the option of resigning. At that time, there was a strong push that, hey, Justice Torkono had worked High Court, Court of Appeal to Supreme Court. And therefore, that matter, for her service to this republic, she should be permitted to resign and take her emolument. So she can go. At least when she resigns, she is entitled to her benefits. Just when they were waiting for that, from nowhere, she decided to do a judicial process, somersault. I think today, she's come to the realization that she ought to have resigned instead of allowing the process to go through.
She said that was not on the table.
Please, I know, and for this privileged information, I cannot even name the people.
Amaliba also came and said it.
Look, two prominent people.
And we supported it here. Remember, you were the
I was opposed to it. You said, look,
yes.
It should be allowed, even though the Supreme Court, because what had happened was that there was a High Court judge who Article 146 process had started against him. Yeah. Then President Mills was in the process of putting the committee together. The CJ then, Georgina Wood, started the process. Then the judge, knowing that if that Article 146 committee concludes its work, he stands the risk of losing his entitlement, quickly tendered in his resignation. So the question was whether President Mills was bound to accept the resignation. And the Supreme Court interpreted the matter and said, once an Article 146 process had commenced, there is no option. If not, you defeat the very purpose of Article 146. But you see, we are back to this point because her ladyship, the Chief Justice, now removed. Options are completely gone.